May I?
We will commence from petition side.
There are 4 petitions where I find Union of India is the party, the cost list, but I would rather prefer to say that I'm addressing the court as Attorney General rather than appealing for any particular party, even though I may have some shades of views which may try to support a point of view which petitioners have presented. So these are 5 cases where I find Union as a party. In the cost list, there's 18, 27, 33, 35, and 36.
Look, may I seek your lordship's permission just to say 2 words with the kind the learned attorney would permit me. There was one aspect which may not have engaged your lordship's attention, that though the code had been brought into force on 21st November 2025, the 2 laws were running in tandem and parallel. But on 2nd February 2026, a notification came to be issued formally repealing the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. My lords may not, I'm not sure whether...
They are not formally on record.
So there's a formal repeal. So now we are considering...
20 Act, 104 section of 2020, the new act, said these acts shall be repealed.
Yes.
Shall be repealed by issuing separate notification.
Yes, but that had somehow escaped their attention. So 2 notifications were issued on 21st November and 8th December, but both of them, they had not executed the formal repeal. That comes on 2nd February. So today, my lord, the situation is that now the
Industrial Dispute Act is
now section completely repealed, and now there's a section 6 of the General Clauses Act and 104 of that governs the thing. So we are really only on the pipeline matters now, which might be in the pipeline under a repeal statute.
pipeline or pending before different forms as you...
In that sense, pipeline, which are pending before your lordships or pending in some high court. But the definition which we are considering here no longer exists.
Exactly.
And the new definition now has formally taken over. It's not running in tandem or parallel anymore. If I can just place those notifications, if it is of assistance, your lordship.
This was keeping in mind this aspect, the subsequent events and the new legislation. That's why on 16th February 26, the day when we kept it for directions, and in para 4 and 5.
I saw that, I saw that.
Pipeline was also keeping in this mind that the issue is now stand quite shortened. It's only for the, as you rightly say, for the transitional matters which originated at the time when the old act was there, until it has been first substituted by in 2020 by the new act and now formally repealed.
Now formally repealed. So only that formal repeal was perhaps not drawn to your lordship's attention on 16th February. And there's also an amendment act of 16th February. In the code has been amended formally by Parliament to encapsulate that repeal.
Yeah. You can ask your junior to
We have made a compilation of the 3 notifications.
Yes.
Just for your lordship, the 3 notifications of 21st November, 8th December, and 2nd February are all 3 there. Just for...
Well, Lord, there is, with your permission, there is one more issue I'd like to flag before the formal hearing begins. My Lord, I would like to alert this court to the possibility that any judgment rendered by this court on the interpretation of the old law will have an impact on the new law. And this, my Lord, may not be fair to us on this side, because now the 2 sides are pretty clear, my Lord. There is one side asking for the reconsideration of Bangalore water supply, and there is this side saying it need not be reconsidered. Now, my Lord, my question for consideration is this. Whatever view your lordship takes of the matter will definitely have an impact on the new law, the definition of industry under the new law, my Lord. And we are not here called upon to address you on the question of the new law. Therefore, my Lord, this danger has to be averted. How do we avert this danger, my Lord, without transgressing into the constitutional validity of the new law, which, my Lord, we want to keep it as an issue which will be raised in times to come. As of today, my Lord, there is no petition pending before you.
That much clarification can be given, that while taking a view with respect to whether the Bangalore water supply or with respect to the original definition
Yes.
under the repealed act, while construing or interpreting that part,
Yes,
I think that if, the word of caution can always be put that this interpretation only relates to the law as it used to be at that time.
my lord, yes. But with respect, my lord, there is an unavoidable overlap. For the reason,
That
my lord,
always
I wish to
happens,
make
that-
it clear, my lord, so that my rights are protected, that's all. The point is, there is an unavoidable overlap between what your lordships may decide and what the new law says. But what the new law does is, it basically, my lord, the crux of the matter today, as far as I see it, is the request on the other side to remove charities and from the
So we are
purview.
hearing that matter for the time being because
But because below the new law removes it. Now the point is we are going to challenge that removal of charities from the new law and also a very wide definition of social work.
any
All social work is excluded from the new law.
that challenge we will independently deal with.
It is true, my lord, but your lordship's judgment will
Just to put it in a different,
find us as far as any challenge to the new law is concerned, my lord. Therefore, I wish to make it clear. All submissions are completely without prejudice to our contention.
Yes,
The
yes.
new law is liable to challenge.
Yes, that of course
That
we
you
clarify.
may keep in mind because
just put it on a different,
submission will be without prejudice.
put it on a slightly different track, taking cue from Ellen submission. Imagine there is benches today assembled to look into a challenge to a new law. Imagine. And then the court will find out whether after a repeal of earlier law and a judgment which prevailed with an earlier law, will it entirely different angle.
True.
Entirely different angle. Therefore, whether in the without a challenge to the new law, as today court is not confronted with
No, I
that.
just want to clarify one thing. There is a challenge to the new law.
Not before this bench.
Can I just complete? It's writ petition 26330.
Mr. Gopal, if there is, we will separately
No,
examine
I'm
that.
just saying we need to
Not
bear in
that.
mind that Parliament has taken a call on the
We
definition
hope
and
that
exists.
we bear in mind and that much basic understanding we possess.
No, no.
Now let's
No,
start.
I'm just clarifying
Values
that-
are started already. I have fixed the
I'm
time.
saying
We will
that-
not allow anything to
That
go beyond that.
writ is pending.
Let's start,
The Lordship
please.
may consider it at some point.
Yes, Mr. Dhandu.
Yeah, Your Lordship. And it's personally speaking, it's I have a lot of reflections and remembrances to how what might have gone into the mind of the learned judge who authored his opinion. And in a manner of speaking, it's a kind of a Kurukshetra here. Now there are only Pandavas on either side. There are no Kauravas and Pandavas. Because both are articulating some various issues on some very common concern. But why is that the court is now called upon?
Yes,
Why the court is now called upon to answer this question at all? But an easy answer would have been that the new law has come, it has taken over the field, and whenever there is an application, a new law, and whatever the precedents occupy the field under the old law, or otherwise repealed or amended or whatever it is, they may be cited in support or cited in opposition under the formulations of the new law. But then we're not arguing in the abstract, because what happened is the new code, the 2020 code, as to a considerable extent, picked up from paragraphs 140 and 141 of the Bangalore water supply. The new definition has picked up something from the judgment. But then the trouble or the question still remains as to number of illustrations which the Bangalore water supply looked into, various activities the Bangalore water supply looked into, and answered either way, they may continue to arise, time and again in future, particularly instances like charitable institutions, philanthropic institutions, education, or by and large, governmental functions. So therefore, when Bangalore water supply was heard, and then if a lot will see Bangalore water supply, right from Banerjee onwards, goes by and large to a large extent on Australian precedents. And because our Industrial Disputes Act was also borrowed to a considerable extent on the Australian law. So more than 1904, 1910 Australian experience. And that's how Banerjee onwards, there was a long discussion on why a large, wider import of the words used in the industrial definition of industry came to be considered. So today, if the court were to say, in terms of the issues framed, can I take your lordship to the courts has framed the issues for consideration in the order dated 16th of February. We have our compilations in volume 1 of my volume 5B. Volume 5B of the compilation. We have made available hot copies also for the court.
4B and 5B for the proper submission. 4B and 5B.
Questions?
I'll be referring to volumes 4B and 5B, which are compilations filed on behalf of the Attorney General. And my written submissions in volume 1A.
1A. Yes, please.
Your Lordship, at page 139 is the order where Your Lordship framed issues. Let me read them and then place my humble observations on how do you go about with answering these issues. Issue number 1, I find issue number 1 has 2 parts. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice V.R. Krishna and so and so, to determine if an undertaking or enterprise 139. Volume 5B.
Running, these are only the judgments which are being relied upon 139.
At page 139, this compilation has an entire set of judgments, including Bangalore Water Supply, and then earlier.
All 37 judgments are.
That's right. So, but I'm reading at page 139.
The order dated 16th February.
16th February 2020, by which Your Lordship framed the issues for consideration by this 9. We don't have hard copy. Let them.
Page 139.
issue, page 139, issue number 1. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice Krishna Iyer in Bangalore Water Supply to determine if an undertaking or enterprise falls within the definition of industry and lays down the correct law. I pause here for a minute. The issue, I think, is advisedly framed like this to only go into the question whether an undertaking or an enterprise falls within definition of industry and lays down the correct law. Now, and whether, second part of it, and whether the Industrial Disputes Amendment Act 1982, which seemingly did not come into force, and the Industrial Relations Code 2020, section so and so, have any legal impact on the interpretation of the expression industry as contained in the Principal Act. So if I consider these as two issues, two separate issues, and because they may have those significance, so let me, then the second issue, whether social welfare activities and schemes or other enterprises undertaken by the government departments or their instrumentalities can be construed to be industrial activities. The issue also again advisedly uses the word enterprises. Then for the purpose of section 2J of the ID Act. Now, 3, what state activities will be covered by the expression sovereign function and whether such activities will still fall outside the purview of section 2J of the ID Act, any other issue that may arise. Now, I think it's important for us then to go back in point of time to the referral order. The earlier order, referral order, as we call it, which is in the same volume at page 94,
90.
which is a reported judgment, 2005, 5 SEC 1.
Yes, we have got to 90.
Yes, the judgment begins at page 102.
Jabir Singh matter.
That's right. Let us look at a couple of paragraphs which probably persuaded this court to enter into a question of a reference, para 2, at page 102, on the question whether Social Forestry Department of State, which is a welfare scheme, undertaken for improvement to the environment would be covered by the definition of industry under section so-and-so. The aforesaid benches, which are noticed in paragraph 1, of this court culled out differently the ratio of the 7-judge bench decision of this court in the case of so-and-so. And both of the 3 judges in the case of Chief Conservator of Forests in Kondera and based on the decision of Bangalore Water case came to the conclusion that the Social Forestry Department is covered by the definition of industry, whereas the 2-judge bench decision in so-and-so took a different view. And the cleavage of opinion between the 2 benches of this court seems to have been at the basis of the 7th bench decision of this court in so-and-so. The present case, along with the other connected cases, the correctness decision in the case was doubted, has been placed before the bench. Various decisions rendered by this court prior to and after the decision in Bangalore Water on the interpretation of the definition of the word industry and industrial disputes act have been cited before us. It's been strenuously urged on behalf of the employers on the expansive meaning given to the word industry with certain specified exceptions carved out in judgment Bangalore Water is not warranted by the language used in the definition clause. It's urged the government and the department, while exercising its sovereign function, have been excluded from the definition of industry. On the question of what is sovereign function, there is no unanimity in the different opinions expressed by judges in Bangalore Water case. It is submitted that in a constitutional democracy, the sovereignty vests in the people all welfare activities undertaken by the state in the discharge of its obligations and the directive in state policy contained in Part 4 of sovereign function to restrict the meaning of sovereign function to only specific categories of so-called inalienable functions like law and order, legislation, judiciary, administration, the like is uncalled for, submitted that the definition of industry given in the Act is no doubt wide, but not so wide as to hold to include all kinds of systematic organized activities undertaken by the state and even individuals engaged in the professional philanthropic activities. Then on behalf of these, I skip paragraph, on behalf of the employers is also pointed out that there is no unanimity in the opinions expressed by the 9 judges in Bangalore water case on the ambit of definition of industry given in the Act. Pursuant to the observations, the legislature responded and amended the Act by the Industrial Resource Amendment Act 1982. In the amended definition, certain specified types of activities have been taken out of the purview. The word industry, the Act stands amended, but the amended provision redefining the word industry has not brought into force because notification to bring this provision, the effect has not been issued in accordance with subsection 2. Section 1, the amended Act, the amended definition thus remains the statute unenforced a period now more than 23 years. Now kindly switch over to the long discussion, Bangalore water supply. Page 110, paragraph 18. There is some point of view that there is a difference of opinion among the judges, but I think it's in a very narrow area. And paragraph 18, Krishnaya himself who delivered the main judgment in Bangalore water at various places in his opinion expressed that the attempt made by the court to impart a definite meaning to the words in the word definition history is only a workable solution until a more precise definition is provided by the legislature. See the following observation. Our judgment here has no pontifical flavor, but seeks to serve the future, however, till changes in the law or industrial culture occur. That's important words. Law, especially industrial law, which regulate the rights and remedies of the working class, unfamiliar with the sophistications of definitions and shower of decisions, unable to secure expert legal opinion what poverty pricing or the justice market, and denying them the staying power to withstand the multi-docket litigation de facto denies social justice. If legal drafting is vigorous and definitions indefinite and court rulings contradictory. Is it possible that the legislative chambers are too preoccupied other pressing business to listen to court signals calling for clarification of ambiguous clauses? A careful prompt amendment of section 2J would have preempted the docket explosion before tribunal and court. I pause here and then kindly come to paragraph 19. Again, paragraph 145, the court echoes the same. I'm going to read it once again when in the course of my submission. 145 is extracted in paragraph 19. I read paragraph 145. We conclude with a diffidence because Parliament, which has a commitment to the political nation to legislate promptly in vital areas like industry and trade and articulate the welfare expectation in the conscience portion of the Constitution, has hardly intervened to restructure the rather clumsy, vaporous, and tall and dwarf definition or tidy up the scheme. Therefore, the court, does Krishna himself think the definition of industry were clumsy, vaporous, and tidy and all that? I'll come back later about that. Then come to a paragraph in the next page, paragraph 21. Just keep it here. The dissenting opinion of Justice Jaswant Singh for himself and Tuldapur Kajay concludes with the following observation. In view of the difficulty experienced by all of us in defining the true denotation of the term industry and divergence of opinion in regard to that too, as has been the case with this bench also, we think it is high time the legislature steps in with a comprehensive bill to clear up the fog and remove the doubts and set at rest once for all the controversy which crops up from time to time in relation to the meaning of the aforesaid term, rendering it necessary for larger benches of this court to be constituted, which has driven the necessity of evolving a working formula to cover particular cases. By the time we did not have the 2020 court, we are still awaiting Parliament. Court thought Parliament is still yet to act. So the above observations contained the dissenting view of Justice Jaswant Singh have proved prophetic. The legislature has intervened and amended the definition of industry in 1982, but for more than 23 years, the amended provision has not been brought into force. The unamended definition with the same vagueness and lack of precision continues to confuse the courts and the parties. I may not agree with that observation, but I'll come to it later. The inaction of the legislative and executive branches has made it necessary for the judiciary to reconsider the subject over and over again in the light of the experience of the working of the provision on the basis of the interpretation judgment in Bangalore water rendered as far back as the year 1978. The next paragraph. In the case of Coy Board, a two-judge bench, the court speaking to Justice Sujata Manohar J, surveyed all previous decisions of the court, including the seven-judge decision in Bangalore Water, and passed an order of reference to the Chief Justice constituting a larger bench or more than seven judges if necessary, the following part of the order. Since the difficulty is arisen because of the judicial interpretation given to the definition of industry in the Industrial Disputes Act, there is no reason why the matter should not be judicially re-examined. In the present case, the function of the coir board is to promote coir industry, open markets for it, and to provide facilities to make the coir industry's products more marketable. That's in the nature of a service. It's not set up to run any industry itself. Looking to the predominant purpose for which it is set up, we would not call it an industry. However, if one were to apply the test laid on Bangalore Water Supply, it is an organization where there are employers and employees. The organization does some useful work for the benefit of others. Therefore, it will have to be called an industry under the Industrial Disputes Act. We do not think that such sweeping tests as contemplated the Industrial Disputes Act, nor do we think that every organization which does useful service and employs people can be labeled as industry. We therefore direct the matter to be placed before the Honorable Chief Justice to consider larger bench should be constituted and so and so. In the next paragraph, when the matter was listed before the bench, three-judge bench, the request for constituting a larger bench for consideration of the judgment so and so was refused both on the ground that the Industrial Disputes Act has undergone an amendment and that the matter does not deserve to be referred to a larger bench as the decision of seven judges bench is binding on the benches of this court or less than seven judges. The order refusing reference to the seven-judge decision by so and so reads thus. We have considered the order made in civil appeal so and so, delivered almost 2 decades ago. The law has since been amended pursuant to judgment, though the date of enforcement has not been notified. The judgment delivered by so and so does not, in our opinion, require any reconsideration or reference being made by a two-judge bench of this court is bound by judgment larger bench. The appeal therefore be listed for the appropriate bench for the election. Thus, the reference sought by two judges to a larger bench of more than seven judges was declined by three-judge bench. As has been held by this court subsequently, in the case of Central Board of Dawari Bora, the so-and-so, it is open to the Chief Justice and the reference made by the two honorable judges to constitute a bench of more than seven judges for reconsideration of the decision in Bangalore Water Supply. 24, next page. In any case, no such inhibition limits the power of the bench of five judges which has been constituted on a reference made due to apparent conflict between judgments of two benches of this court. As has been stated by us above, the decision in Bangalore Water is not an unanimous decision. Of the five judges who constituted the majority, three have given a common opinion, but the two others have given separate opinions projecting a view partly different from the views expressed in the opinion of the other three judges. Beg CJ, having retired, had no opportunity to see the opinion delivered by the other two judges subsequent to retirement. Krishna J and the two judges who spoke to him did not have the benefit of dissenting opinion of the two other judges and a separate partly dissenting opinion of Chandrachud Dey, as those opinions were prepared and delivered subsequent delivery of the judgment in Bangalore Water case. Probably that seems to the dynamics of this court with its combination of benches of more than two. In such a situation, it's difficult to ascertain whether the opinion of Krishna J given on behalf of Bhagavati and Desai J can be held to be an authoritative precedent, which would require no reconsideration, even though judges themselves expressed the view that the exercise of interpretation done by each one of them was tentative and is only a temporary exercise till the legislature stepped in. Legislature subsequently amended the definition, but due to lack of will both on the part of the legislature and executive, the amended definition for long period 23 years has remained dormant. Sri So-and-so is appearing for National Remote Sensing Agency, which is an agency constituted by the government in discharge of its sovereign function dealing with defense, research, atomic energy, and space, falling in the excluded category in subclass 6 with the amended definition industry in section 2J, relies on the following decision in support of its submission that where the unamended definition in the Act is ambiguous and has been interpreted by the court not exhaustively but tentatively, until law is amended, the amendment actually brought into the statute can be looked into for consideration, for construction of the unamended provision. Then next paragraph, Andhyajana further argues that the Industrial Disputes Act 1982 noted the views, not only of the definition of industry as provided in various other provisions, the Principal Act also amended. Subsection 2(1) of the Amendment Act say the Act shall come into force in that day so-and-so by notification the official gazette point. It submitted either the whole of the Act should have been notified for enforcement or not at all. The Amendment Act does not contemplate a situation where the central government notify only some other provisions of the Amendment Act for enforcement and withhold from enforcement other provisions Amendment Act. It's argued that such piecemeal enforcement act is not permissible by subsection 2, so and so, it is Benian. Then little later, and then I skipped that particular paragraph, come to paragraph 28. Senior advocates with O.J. Singh and Colin Gonsalves, counsel appearing for the employees very vehemently oppose a prayer made on behalf of the employers for referring the matter to a larger bench for reconsideration of the decision in Bangalore water case. I think they have the same stand today. It is submitted that even though the definition of the industrialist books have been amended in 1982, it has not been brought into force for more than 23 years, and the reason disclosed to the court when the enforcement of the Amendment Act was sought in the case of Ultimate Shreen in its sound justification, the stand of the UN of India was for the category of industries. Excluded the amended definition, no alternative industrial dispute resolution forums could be created. For the opposite reason, the central government did not enforce the provision of the Amendment Act, which provided a new and restrictive definition of industry. Then the council with the employees relied on AKRI in support of the submission that is not open to the court to issue the amendments to the government to bring into force the provisions of the Act. Submit that the prerogative of the government in accordance with the provisions of the Amendment Act to enforce the provisions of the Act when it finds that there are conditions suitable to take out the purview of the definition of industry, certain categories of industries in which the employees have been provided separate forums for the redressal of the industrial disputes. Then paragraph 30, on behalf of the employees submitted pursuant to the decision, although the legislature responded by amending the definition of industry to exclude certain specified categories of industries from the purview of the Act, employees of the excluded categories of industries could not be provided alternative forums for redressal of the grievance. The unamended definition of industry as interpreted in Bangalore Water has been the settled law of the land in the industrial field. The settled legal position has operated well, and no better enunciation and scope and effect of the definition could be made either by the legislature or by the Indian Labour Organization in its report. That's a very ambitious statement. Then kindly come to the court looks at paragraph 35 at page 117.
33 also.
Where fireboard is referred to, and for good reason they're referring to paragraph 19. After paragraph 19, which I read out earlier at page 118, this is how the referral order reads. The above quoted observations were criticized on behalf of the employees, stating that for making them, there was no material before the court. We think that observation of the learned judges is not without foundation. The experience of judges in the apex court is not derived from the case in which the observations are made. The experience was from the cases regularly coming from to the court, to the labor court. It is experienced by all dealing in industrial law that overemphasis on the rights of the workers and the undue curtailment, the rights of the employees to organize the business through employment and non-employment has given rise to a large number of industrial and labor claims resulting in awards granting large amounts of back wages for past years, allegedly as legitimate dues that the workers are found to have been so and so. Then after placitum, yes, the awards of reinstatement and the arrears of wages for the past years of labor codes by treating even small undertakings of employers and entrepreneurs of the industry's experience as a serious industrial hazard, particularly with those engaged in private enterprises. They experience that many times idle wages are required to be paid to the worker because the employer has no means to find out whether and where the workman was gainfully employed pending adjudication. The exploitation of workers and the employers has to be equally checked. Law, and particularly industrial law, needs to be interpreted as to ensure that neither the employers nor the employees are in a position to dominate the other. Both should be able to cooperate for their mutual benefit in the growth of industry and thereby serve the public good. An over-expansive interpretation might be deterrent to private enterprise in India where public employment opportunities are scarce. The people should therefore be encouraged towards self-employment, embrace within definition of industry even liberal professional like so-and-so and the like, which are occupations based on talent, skill, and intellectual attainment, is experienced as a hurdle by professional self-pursuits in carrying on their profession in a city. No doubt, even liberal professions are required to be regulated and reasonable restrictions imposed. If you adopt an ideological, philosophical approach, we would be treading on the wrong path against which learned Sri Justice Krishna Iyer himself recorded a caution in his inimitable style thus. Here we have to be cautious not to fall into the trap of definitional expansionism, bordering on reductio ad absurdum, not to truncate the obvious amplitude of the provision to fit into our mental mold of beliefs and prejudices or social philosophy conditioned by class interests. Subjective it shall not be father to the forensic thought, if credibility with a pluralist community is a value to be cherished. Courts do not substitute their social and economic beliefs for the judgment of legislative bodies. I think very often we take a different note on this. Of course, courts do, but then how far they can do is a different question. So a worker-oriented approach in construing the definition of industry, unmindful of the interests of the employer or the owner of the industry and the public who are the ultimate beneficiaries, would be a one-sided approach and not in accordance with the provisions of the Act. We also wish to enter a caveat on confining sovereign function to the traditional so described as inalienable functions comparable to those performed by a monarch, a ruler, or a non-democratic government. The learned judges in Bangalore supply seem to have confined only such sovereign functions outside the purview of industry which can be termed strictly as constitutional functions of the three wings of the state, executive, legislative, and judicial. The concept of sovereignty in a constitutional democracy is different from the traditional concept of sovereignty, which is confined to law and order, defense, lawmaking, justice dispensation. In a democracy governed by the Constitution, the sovereignty of the people and the state is obliged to discharge its constitutional obligation contained in the directive principle of state policy. From that point of view, wherever the government undertakes public welfare activities in discharge of its constitutional obligation, as provided in Part 4 of the Constitution, such activities should be treated as activities in discharge of sovereign functions falling outside the purview of industry. That's what your Lordship is going to look at in the second and the third issue. Whether employees employed in such welfare activities of the government require protection, apart from the constitutional rights conferred on them, may be a subject of separate legislation. Please kindly mark it. May be a separate subject of separate legislation, but for that reason, such governmental activities cannot be brought within the fold of industrial law by giving an undue expansive and wide meaning to the words used in the definition of industry. In response, Parliament intervened and substituted the definition of industry by including with its meaning some activities of the government and excluding some other specified governmental activities and public utility services involving sovereign function. For 23 years, the amended definition has remained unenforced. Government has been experiencing difficulty in bringing into effect the new definition. Issuance of notification has been withheld so far. It is therefore high time for the court to re-examine the judicial interpretation given by it to definition of industry. The legislature should be allowed to greater freedom to come forward with a more comprehensive legislation to meet the demands of employers and employees, the public and private sectors. The inhibition, the difficulties arise being exercised by the legislature and the executive in bringing into force the amended industrial law, more due to judicial interpreted definition of industry need to be removed. The experience of working with the Provisions Act should serve as a guide for a better and more comprehensive law on the subject to be brought into force without limitation. Now that we have reached that stage, 1982, an unnotified law is no longer part of the canvas. So now that we've reached the 2020 code, a couple of questions may arise in your mind as Ms. Jay Singh was trying to canvas. Now, what is that important public purpose that will be served by this court looking into the Bangalore water supply in its expansive sweep and say that in one way or the other, to some extent or the other, the Bangalore water supply is not good law. There has to be some impact factor, I suppose. Is it because the new code, which is partly lifted from Bangalore water supply in the definition of industry, but partly departing from it? Therefore, if your Lordship say that it's partly good law, certainly is going to carry on and have its cast a shadow on the application and interpretation of the new code. But to say on the other hand, no, don't do it at all. The new code will take care of itself. Therefore, there is some problem where the court may have to very carefully tread. So the court were to say, well, it's good law for all practical purposes. And the new code will certainly receive its color from this court's imprimatur of the Bangalore water supply. And to what extent that exercise will be undertaken is also a question for Lordship's consideration. And let me complete this and then come to it. Paragraph 42.
Yes.
I'm leaving for the time being para 41, para 42. In construing the definition and definition clause and determining its ambit, one has not to lose sight of the fact that in activities like hospitals and education, concepts like the right of the workers to go on strike or the employer's right to close down and lay off are not contemplated because their services, in which the motto is service to the community, if the patients or students are to be left at the mercy of the employer and the employees, exercising their rights at will, the very purpose of service activity would be frustrated. That we are respectfully inclined to agree with the observations of Jadendra Gadkar in Harinagar case, as we have repeatedly emphasized. In dealing with industrial matters, industrial adjudication should refrain from enunciating any general principle or adopting any doctrinaire considerations. It is desirable that industrial adjudication should deal with problems as and when they arise and confine a decision to the point which strictly arise on the pleading between the parties. That's a very ambitious statement, if I can put it like that, because when you have issues like an industrial definition, to say that can be no room for doctrinal considerations is going to be a problematic statement. But that apart, the court is only bringing an attention to the fact that notwithstanding those doctrinal considerations, can you go beyond them to the extent that's possible? That's what perhaps Gajendra Gadkar is talking about here. We conclude agreeing with the conclusion of honorable judges in Hospital Madhu Sabha. Though Section 2J use words a very wide denotation, a line would have to be drawn in a fair and just manner so as to exclude some calling, services, or undertaking. This court must therefore reconsider where the line should be drawn and what limitations can and should be reasonably implied in interpreting the wide words in Section 2J. That, no doubt, is rather a difficult problem to resolve, more so when both the legislature and the executive are silent and have kept an important amended provision on the law dormant on the statute book. We'll come to it.
The new board. It's a different body.
I've taken my note. My note. Points. Points should be noted.
So the new board will be able to supply.
You may read para 45 before concluding this judgment.
Your Lordship, please, sir.
You may just read para 45 also.
Yes, yes. I'll come. We do not consider it necessary to say anything more and leave it to the larger bench to give such meaning and effect to the definition clause in the present context. With the experience of all these years and keeping in view the amended definition of industry kept dormant for long 23 years, pressing demands for the competing sectors of employers and employees, and the helplessness of so and so, the Amendment Act compels us to make this reference. So perhaps that's what persuaded your lordships to have the second part of issue 1, which says what is the impact of amended 1982 amendment and the current code.
We may add one more angle to this matter. Bangalore Water Supply is a judgment which came in 1970s. We have the reforms of 1991, which has focused on liberalization, privatization, and globalization. Now, if there is going to be more focus on privatization and liberalization, many of the functions which the state was doing would be performed by the private sector. Then what should be the scope of the definition of industry? Should it still be very expansive, or should it be restricted, or a balance has to be struck? I think that is one of the angles of this case, since that judgment is delivered almost half a century ago.
Correct.
Now we are in 2026, and we have had how many years of liberalization? I say LPG, liberalization, privatization, globalization.
Correct.
Which is so important for a woman also, LPG.
No,
All I say.
not,
So for a.
there's no shortage of LPG.
Can't get it.
There's no LPG shortage today here as far as that is concerned.
Small typo.
No, but responding to your lordship's observation, let me place the.
Half a century ago, we were on socialist philosophy and you know what has happened in the property owners case,
That's right.
Ranganatha Reddy, etc.
It's a very important observation.
Yes.
Let me respond to it quickly before I go into the larger question. Now, whatever socio-economic changes happen in a community or a country, particularly where you're talking about liberalization, etc., globalization, privatization, opening up market in a big way, the question will still remain if the definition of industry in 2J had continued to occupy the statute. Then, of course, we need to call in the context of a definition which remains unchanged, whether Bangalore water supply would continue to provide us enough guidance, or we need to go a little away from that or move away farther from that. But today, since we don't have that situation at all, we have both a 1982 interlude, not notified, and a later code which is now occupying the field. Therefore, I think Lordships will have to probably answer these issues in a very narrow perspective as to whether between 1978 to 2020, will it be a good only for the purpose of answering those matters which are pending before the court.
Yes.
That's
Matters are
That's
pending
right.
before the
If it's
court.
only for a limited purpose, then of course,
Now they can't.
court need not travel a long line of entering into all the debates about what would be sovereign function, so on and so forth. But if it's for a larger, canvas, then I think I would probably tell the court, be slow in looking into this issue, because the new code, to a considerable extent, has borrowed from para 140 of the Bangalore water supply, but has departed in certain respects. For whatever the court may say today, whether Bangalore water supply in its entirety or partly or rule partly approved or whatever it is, will certainly cast a shadow on the interpretation of the new code, to the extent it has some overlapping. Therefore, I thought it was only for the purpose of answering and responding to the matters pending prior to 2020. Perhaps we walk on a very narrow path. Many larger considerations need not enter the mind of the court in unraveling Bangalore is a good law, a bad law, doctrine, no doctrine, etc. So I thought that's something I'm not very clear whether.
It should be activity based.
Yes.
For example, social forestry. Activity based has to be considered.
May I presently place therefore how, for instance, from 2J in the 1947 Act, 1982 definition, and then the current definition. I'll quickly place that so that we have a perspective on where we should probably stop and where perhaps the logos will not go further. Now, kindly take in the compilation.
Just one question.
I'm sorry.
This is referred to para 45.
Yes.
Now, where do we find in the judgment what the pressing demands of the competing sectors were and what difficulties were faced by the legislature and the executive to enforce the amended definition of industry, which compelled the 5-judge bench to make the reference? Where is that discussion?
No, they go through. There are 3 or 4 cases which have been dealt with. Kindly come back to paragraph.
No. Paragraph 45 as mentioned refers to, this is the final conclusion, that it is because of the pressing demands and the helplessness of the legislature and executive that we are making a reference.
No, the code goes back to, the code goes back to Bangalore water supply itself to say that Bangalore water supply, both in terms of Justice Krishna's judgment and the opinion by Justice Jaswant Singh and Justice Tulgapurkar, and partly Justice Chandrachud, also take note of it. Now I think that's where, yes.
Please come back to 45.
Yes.
It refers to an incident which was not there when Bangalore water supply was decided. They say that the legislature and the executive are helpless in bringing into force the Amendment Act. That is 1982.
Yes.
That was not there in Bangalore water supply. It precedes 1982 amendment. What prevented the legislature and the executive to enforce the Amendment Act, which is compelling the 5 judges bench to refer it to the Chief Justice. Where do we find that?
No, there is no.
It's not there?
No, there is no material available in the
In
judgment.
the judgment.
But then,
If it is
but
not
then
there,
are you
Mr. Attorney,
placed on record?
what is, we would, at least I would be questioning you.
Yes.
Whether it's a valid reference.
No, but
Whether it's a valid reference, first.
yes,
Secondly, the bench has, in paragraph 24,
yes.
has repeatedly said, this is not an unanimous opinion.
It is.
Madam, just 1 minute.
24, yes.
24, Bangalore water supply, fourth line is not a unanimous decision. Of the 7, 5 were on one side, 2 were on the other side. How is it relevant?
No, I'm not.
7-judge bench, it has to be considered as a 7-judge judgment.
Let,
Srimurthy Fragrances quite recently says,
yes.
irrespective of the number of judges dissenting, it has to be taken as the judgment.
I'm not here to support that at all.
Not
Now, let's look at it from,
Read opinion which has to. That is the law. There may be.
Yes.
let me put it,
This is the first thing. The 5-judge bench says that it is not a unanimous, as if this is a ground for making a reference. Secondly, Justice Iyer, on behalf of Bhagwati and Desai JJ, whether it can be held to be an authoritative precedent. A 5-judge bench questioning the 7 judges bench.
Yes.
no, that's why when this difficulty arose,
When referring to
that's why when the difficulty
Dr. Manohar's judgment, which was placed before a larger bench, the larger bench did not agree with the 2-judge bench and did not refer.
that's why when the difficulty arose, kindly turn to why
social funds.
They were different opinion.
at page 113, the court, when the earlier endeavor in choir board did not meet with the approval by a subsequent 3-judges bench, at page 113 bottom, that's how these references ultimately been made. So I do not know. I do not know. I'm course, to come back to page 113.
Apropos
the
what
bottom,
fell from my Lord
and then
Justice
there is
Datta, I can just point out one more, one more aspect, my lord.
We will not permit Mr. Ansari.
Let me,
It's not the way to, let him complete first of all.
page 113 at the
Not
bottom.
anyone to interrupt.
Page 113 bottom, that the reference sought by the two judges to a larger bench was declined by a three-judge bench, as has been held by the court subsequently in the case of Central Board of Dawudis also.
113, where are you?
Is open to the Chief Justice.
Paragraph? 113.
Page 113 at the bottom. It at the bottom of that page.
Thus, the reference sought by two judges to a larger bench or more than 7 judges were declined by the 5 judge bench. Rightly so, because that's contrary to rules.
Perhaps this is also
Then
not
as
a
has
correct
been-
statement, Mr. Attorney.
One minute, let me,
Judges can refer it to three,
One
3 to
minute.
5, 5 to 7,
That's
and
right.
this is the course that has been followed.
let me complete the let me complete the
Not that
history.
You can directly refer it to
Let me
7.
complete the history. That's right. I'm not yet completed the history. So that's how I think it came before a bench of 5 judges. Now kindly turn to page 1, 2, 3.
This last line is absolutely correct statement of law, because under the Supreme Court rule, Chief Justice.
The
has-
Chief Justice takes a call on that, and the 5 judges bench is constituted. The 5 judges bench take a view that there is a need for a reference, and then the matter goes before a bench of 7 judges at page 123, and we have the order at page 125. So in a manner of speaking, when the 7 judges bench place its stamp of approval on the reference, that's how, now it's before your lordship, page 125. Your learned counsel for the parties at considerable length have been taken through so-and-so, and the reference order passed by a 5 judges bench of the court pursuant to which these matters have been placed before us, having given our anxious consideration to the contentions urged at the bar, and the serious and wide-ranging implications of the issue that fall for determination, as also the fact that serious doubts have been expressed in the reference order about the correctness of the view taken and so on. So, we are of the opinion that these appeals need to be placed before a bench comprising 9 judges to be constituted by the Chief Justice. We order accordingly papers to be so and so. Therefore, a 7 versus 7. Bangalore 7, this 7. Therefore, I don't know whether that part of a referral process need to halt your lordship on the further inquiry. And now that we have traveled this distance, the only importance would be, as I said to point out earlier, is that what is the area to be covered by this referral?
So we can examine all issues, but learned attorney, you proceed on the premise that there is a reference to 9 judge bench.
Yeah.
And we have to examine Bangalore bars.
That's right.
Page 4 of this information. Just page 4.
They say that the bench also.
Good point.
May then take your lordships to Bangalore water supply itself directly.
This is volume.
Volume,
Volume 1, it's volume 1. 8, volume 8, eh?
1A.
1A. This is market. We have set out the issues which Bangalore water supply is self-framed in paragraph 23 of its opinion.
What is that? This submission.
29.
Page 29.
Is
Page 29. This is paragraph 23 of Bangalore water supply, which is at page 25 of volume 5B. I thought for the
paragraph
convenience sake.
37. Paragraph 37 are you referring to?
Yes.
That's right, 37.
Yes.
Of Bangalore water supply.
No, he said in paragraph 37 of volume 1A.
My written submissions, no.
The attorney's written submission.
Reproduce.
On 1 AM 5 days.
Your lordships also may alongside keep the judgment compilation, which is volume 5B, but I'll be probably reading between my submissions and Bangalore water supply concurrently. That para 23 is at page 25 of the judgment compilation, which is volume 5B.
Yes.
I have extracted here only for convenience. That's right.
We are around.
If your lordships also, I said, keep open page 25 of volume 5E for a minute before I read these issues. Because almost every page of Bangalore water supply has some beautiful literature and something which goes far into our visionary thinking as well as the problem which the court encountered.
Has to be read along with a dictionary. Judgment of justice.
I mean, we cannot close our eyes and mind to the masterpiece of literature available in judgments, and they are so instructive and also guide us in ways of thinking in unknown and novel ways. I want to read paragraph 22 at page 25 before I take out of the issues. Page 22 of volume 5B. A counter critic, on the other hand, may acidly contend. Will Lords have that page?
Yes, please proceed.
Yes. May acidly contend that if judicial interpretation uninformed by life's realities were to go wild, every home will not be a quiet castle but a tumultuous industry. Every research unit will grind to a halt. Every god will face new demand, and every service club will be the venue of rumble.
You're reading where?
I'm reading page 25 in volume 5B. I want to keep both of them together. Paragraph 22 at the top of that page.
23 is reproduced in the submission.
That's right. But I just want to
Before
read
that, you wanted to read para 22.
para 22.
Yes.
So, yes, the counter critic.
Critic may, on the other hand, may acidly contend that if judicial interpretation uninformed by life's realities were to go wild, every home will be not a quiet castle, but tumultuous industry. Every research unit will grind to a halt. Every god will face new demands. What do you want? We did Bangalore water supply. Yeah.
20, 23, 29, 31 supply.
And every service club will be the venue of rumble and every charity choked off by brewing unrest and the salt of the earth as well as the lowliest and the lost will suffer. Counsel for the appellant struck this pessimistic note. Is it not obvious from these rival thought-ways that law is value-loaded and the social philosophy is an inarticulate interpretative tool? This inescapable Indian school of jurisprudence. Probably just Krishna had in his mind Maxim Gorky's The Mother. It talks about how the industrial class, and it's a very picturesque way. Now let me read these issues. Now let us itemize illustratively the posers springing from the competing submission so that contentions may be concretized. 1A, or establishments run without profit motive industries. B, or charitable institutions industries. C, to undertakings governed by a no profit, no loss rule statutorily but otherwise fashioned fall within the definition of section 2J. Do clubs, other organizations like YMCA, whose general emphasis is not on profit making, by fellowship and self-service, fit in the definitional circle? To go to the core of the matter, is it an inalienable ingredient of industry that should be applied with a commercial object? 2A, should cooperation between employer and employee be directed insofar as it relates to the basic service and essential manufacturer, which is the output of the undertaking? Could a lawyer's chamber, a chartered accountant's office, a doctor's clinic, a liberal professions occupation, a calling be designated the industry? Whether a university or a college or a school research institute be called an industry? Is the inclusive part of the definition in section 2J relevant to the determination of an industry? If so, what impact does it make on the categories? Do domestic service drudges who slave without respite become industries by this extended sense? Are governmental functions stricto sensu industrial, and if not, what is the extent of immunity of instrumentalities of government? What rational criteria exists for a cutback on the dynamic potential and semantic sweep of the definition? Implicit in the industrial law of a progressive society geared to a greater industrialization and consequent concern for regulating relations and investigating disputes between employers and employees, the industrial process and relations become more complex and sophisticated, and workmen become more right conscious. As the provision now stands, is it scientific to define industry based on the nature, the dominant nature of the activity, that is on the terms of the work, remuneration, and conditions of service which bond the two wings together into an employer-employee complex? I think we should read all the three definitions.
Yes.
Vilash, kindly, before I go further on reading Bangalore water supply, kindly pick up volume 4B, where we have complete compilation of statutes. Volume 4B. It's titled Statutory and Documentary Materials.
This is so amended.
It is amended.
You just read this now.
Original, it is amended. I think we should read this also. Then we go to look.
Yes.
Still handing it over. Still handing it over. Ultimately, they don't have it in this paragraph 10 extract the original definition.
I know.
We step into the extracted paragraph 10. If they could.
At page 427 of this compilation, volume 4B, we have both the original definition and the amended definition in 1982, page 427. Industry means at the top of it. That originally it was 2J. Industry means, we'll also have that page.
It's 424.
427. Volume 4B. Industry means any business, trade. I just, for the sake of argument, I just close my eyes for the other word, undertaking. I continue to read as if the word undertaking is not there for the time being. So industry means any business, trade, manufacture, or calling of employers, and includes any calling, service, employment, handicraft, or industrial occupation, or avocation of workmen. Now, in a large number of cases, what we will find, the word undertaking has come up for consideration, both in the context of municipalities and few other instances, the word undertaking has received a lot of attention. And therefore, whether it's a nociter of sources or an ejusdem generis principle, the court has employed either of them and said, I come to an understanding that undertaking must receive a widest import, whether or not there is a profit motive, a commercial element, and so on and so forth. That's why at the bottom of it, Bangalore Water Supply has reached that wide canvas. Now let undertaking remain there as it is. At the same page, the amended act definition is also available. Now this is how it reads. Industry means any systematic activity carried on by cooperation between an employer and his workmen, whether such workmen are employed by such employee directly or by through an agency, including a contractor, for the production, supply, or distribution of goods or services with a view to satisfy human wants or wishes, not being wants and wishes which are merely spiritual or religious in nature, whether or not any capital has been invested for the purpose of carrying on such activity, or such activity is carried on with a motive to make any gain or profit and includes. I skip again for the time being this block label A and B. You'll also come to paragraph 140 of Bangalore Water Supply. Just to make a quick note, page 14, paragraph 140 in volume 5B at page 73.
Page 73.
Page 73, page paragraph 140. That is the concluding part where the court endeavors to define industry as defined and explained in Banerjee as a wide import. A, where a systematic activity organized by cooperation between the employer and the employee. The direct and substantial element is chimerical, but the production and the distribution of goods and services calculated to satisfy human wants and wishes, not spiritual religious, but inclusive of material things of services geared a celestial beings making a large-scale prasada food, prima facie, that's an industry. That's what the 1982 amendment tries to capture. And a little later, absence of profit motive or gainful objective is irrelevant, be the venture in the public, joint, private, other sector. Then true focus is functional, and 3D organization, the trade business, it does not cease to be so and so. I come back to page 427. Then we see once this definition is more or less borrowed from this part of one paragraph 140, then to the extent what the court was anxious to know, whether the law is now to be on the lines we have debated, that's answered in 1982 to a considerable extent. But the 82 Act also excludes certain parts of definition of industry. Page 427, after F1, 2, A, B, etc., there's the middle, but does not include. But does not include, one, any agriculture operation, except that agriculture operation is carried on in an integrated manner with any other activity, and such other activity is the predominant one. Then explanation for the purpose of subclause, agriculture operation does not include any activity carried on in a plantation as defined in so-and-so Plantation Labor Act, or two, hospitals or dispensaries, 3, educational, scientific research or training institutions, or 4, institutions owned or managed by organizations only or substantially engaged in any charitable, social, or philanthropic service, or khadi or village industries, or any activity of the government. This is important. Any activity of the government relatable to the sovereign functions of the government. It uses the word very carefully. Activities relatable to the sovereign functions of the government, including all the activities carried on by the departments of central government dealing with defense research, atomic energy and space, or any domestic service, or any activity being a profession practiced by an individual or body of individuals, if the number of persons so and so a body of individuals in relation to is less than 10, that takes care of clubs, associations, etc. Any activity carried on by a cooperative society or a club like body of individuals, if the number of persons employed so and so is less than 10. Now kindly turn to in the same volume at page 701. We have the definition in the new code.
Is there a comparative study made between what has been stated in the judgment with the 1982 amendment and between the 1982 amendment and the labor code?
There have been large number of
distinction.
There have been large number of discussions, consultations. There is
Comparative study, it would be useful to the court.
I can place it. There is some consultative committee. There is a parliamentary consultative committee. One minute.
Chart.
That chart will be useful.
We'll place it.
We'll place the comparative chart.
We'll place all those better. I thought for the time being,
My lunch provided.
You keep it, there is no need.
701.
Yes, Mr. Attorney, let's proceed further. 82 definition, we are not sure how much it is going to help you, as my brother has already pointed out.
That's
Will of the
so
legislature
this part of
became
this,
of the executive.
the first part of it is as it was in the 1982 Act. Sorry. So at page 701, the definition of industry, the first part of it, I may call it, is parliamentary of the 1982 Amendment Act. And that's again para 140 of the Bangalore Water Supply. But then here, after that, but does not include, we also have a non-inclusion, exclusion clauses. But this exclusion clause is not the same as what 82 amendments sought to bring in. This is a little narrow, but I think it's also important to keep it in mind. So it says, but does not include institutions owned or managed or organizations only or substantially engaged in a charitable, social, or philanthropic service. Then 2, any activity of the appropriate government relatable to the sovereign functions of the appropriate government, including all the activities carried on by the department, central government dealing with defense research, so and so, or any domestic service, and any other activity as may be notified by the central government. I think the parliament has gone very advanced to say if from time to time if there is a need to going by these principles and by any other principles which the state may consider important and relevant, may notify it. Otherwise, they may still say it can be an industry, it need not be an industry. Therefore, these clauses, of course, occurs in many legislations, but in the context of a law like this, it has taken color from the other part of the definition. Therefore, that's the statutory scheme as it exists today. So if keeping this in mind, let me take your lordships to the Bangalore water supply itself. That's volume 5B. The judgment begins from page 4. May I invite your lordship's attention to. I come. An introductory paragraph where the court finds at page 19 of the judgment, paragraph 4. Though the tailoring of a definition is the sole forensic job in this batch of appeal, dependent on which perhaps a few thousand other cases await decision. The cycloramic semantics of the simple word industry and the judicial gloss on it in a category of cases have led to the avoidable glut of labor litigation where speedy finality and working criteria are more desirable. And this delay in disposal of thousands of disputes and consequent partial paralysis in the industrial life is partly blamable on the absence of mechanism of communication between the court and the lawmaking chamber. Cycloramic means a 360-degree panoramic view. That's what it means. Kindly turn to paragraph 18.
Court judgment and the Supreme Court.
13. Okay, fine. Kindly turn to paragraph 13 at page 21.
These three elements are 13, 14, and 15, taken from hospital.
Yes. Look at the definition.
Yeah, look at the definition. Dictionary in hand, decisions in head, and constitution at heart. Leads to some sure characteristics of an industry, narrowing down the twilight zone of a turbid controversy. An industry is continuity, is an organized activity, is a purposeful pursuit, not any isolated adventure, desultory excursion or casual, fleeting engagement motivelessly undertaken. Such is the common feature of a trade, business, calling, manufacture, mechanical, handicraft-based service, employment, industrial occupation, or a vocation. I find that these propositions have been picked up from Hospital Mazdoor Sabha and then earlier judgment in Nagpur Corporation. I'll come to them a little later. Then paragraph 14. Likewise, an industry cannot exist without a cooperative endeavor between employer and employee. No employer, no industry, no employee, no industry, not as a dogmatic proposition in economics, but as an articulate major premise of the definition and scheme of the Act, and as a necessary postulate of the industrial disputes and statutory resolution thereof. An industry is not a futility, but geared to utilities in which the community is concerned, and in this mutant world where law is now economic utilities, material goods and services, not transcendental files nor intangible achievements, or the functional focus of industry. Therefore, no temporal utilities, no statutory industry is axiomatic. If society in its advance experience subtle realities and assigns values to them, jurisprudence may reach out to search collective good. Today, not tomorrow, is the first charge of pragmatic law. So and so we're confined to material, not ethereal end products. And these paragraphs 13, 14, and 15 ultimately get coined as a triple test formula in paragraph 140. Let me go to paragraph 18. And before I read paragraph 18, what, of course, obviously prompted the dialogue, the court says, the last few lines in paragraph 17, the betterment of the workman's law, the avoidance of outbreaks, blocking production, and just and speedy settlement of disputes concern the community in trade and business, goods and services are for the community, not for self-concern. Then para 18. The penumbral area arrives as we move into the outer. Other essentials needed to make an organized, systematic activity, oriented and productive collaboration between employer and employee. An industry as defined in section 2J. Here we have to be cautious not to fall into the trap of definitional expansionism, bordering on reductio ad absurdum, not to truncate the obvious amplitude of the provision, to fit into a mental mold of beliefs and prejudices and social philosophy conditioned by class interests. Subjective wish shall not be father to the forensic thought. If credibility with pluralist community is a value to be cherished, courts do not substitute their social and economic beliefs for the judgment of legislative bodies. Even so, this legislation has something to do with social justice between the haves and the have-nots. And naive, fugitive, and illogical cutbacks on the import of industry may do injustice to the benignant enactment. avoiding scilla and charybdis, we proceed to decipher the fuller import of the definition. Your Lordship knows scilla and charybdis means between two dangerous things, the devil and the deep sea. So avoiding scilla and charybdis, we proceed to decipher the fuller import of the definition. To sum up, the personality of the whole statute, be it remembered as a welfare basis, it being a beneficial legislation which protects labor, promotes their contentment, regulates situations of crisis and tension of production may be imperiled by untakeable strikes and blackmail lockout. The mechanism of the act is geared to conferment of regulated benefit of the workman and resolution according to a sympathetic rule of law of the conflict's actual potential between management and the workman. His goal is amelioration of the conditions of workers tempered by a practical sense of peaceful coexistence in the benefit of both, not a neutral position, but restraints on laissez-faire and concern for the welfare of the weaker lot. Then a few lines later, this certainly does not mean that we should strain the language of definition to import into it what we regard as desirable in an industrial legislation, for we are not legislating de novo, but construing an existing act. Crusading for a new type of legislation with dynamic ideas and humanistic justice, an industrial harmony cannot be under the umbrella of interpreting an old imperfect enactment. The court thinks that 2J was an imperfect enactment. I only want to keep this in mind when you're going beyond the reach of 2020. The new enactment has come. So imperfect enactment has now been substituted with what Parliament thinks is a possibly reasonably good enactment. Then kindly turn to paragraph 21. A cynical jurist surveying the forensic scene may make unhappy comments. Counsel for the respondent unions sounded that note. A pluralist society with capitalist backbone, notwithstanding the innocuous adjective socialist added to the Republic by the Constitution, regards profit-making as a sacrosanct value. Elitist professionalism and industrialism insensitive to the worker menace and inclined to expose a sound and fury of the labor unrest from its sanctified pressing by judicially deindustrializing the activities of professional men and interest group to the extent possible feasible. Governments in a mixed economy share some of the habits of thought of a dominant class and doctrines like sovereign function, which pull out economic enterprises run by them, come in handy. I thought this is a very broad observation made. Now, the latent love for club life and charitable devices and escapist institutions bred by clever capitalism and hierarchy of so and so, I'm not placing so much of emphasis on these aspects because we are more concerned with the larger canvas. Now, the second part of exclusion in the new definition, the same exclusion in the 1982 definition as to those activities relatable to sovereign function will ultimately...
Already referred to by you.
Right. No,
28.
I come. And page 28, I'll read two paragraphs at page 28, para 28 and 29. The second, though trite guidance that we get is that we should not be beguiled.
27 first. 27 first.
Beguiled by similar words or dissimilar statutes, context, subject matters, or socio-economic situations. I think that's a very ideal call. And the same word may mean one thing in one context and another in different context. There's a reason why decisions on the meaning of particular words or collection of words found in other statutes are scarcely of much value when you have to deal with a specific statute of your own. They may persuade but cannot pressure. But why they say that in the previous page 27, paragraph 27, where the court extracts from Banerjee.
26 is the extract and 27 they explain.
The court begins to deal with Banerjee from para 24 onwards, but let me only quickly take your lordships to two extracts from Banerjee court set out in paragraphs 26 and 27 at page 27. A panoramic view of the statute and its jurisprudential bearings have been projected there and the essentials of an industry decocted. The definitions of employers, Section 2G, industry, industrial dispute, workmen, or a statutory dictionary, not popular parlance. It is plain that merely because the employer is a government department or local body, and a fortiori, a statutory board, society or like entity, the enterprise does not cease to be an industry. Likewise, what the common man does not consider industry does not necessarily stand excluded from the statutory concept and vice versa. The latter is deliberately drawn wider and in some respects narrower, as Chandrasekhar Iyer J. has emphatically expressed. Let me read this paragraph. In the ordinary and non-technical sense, according to what is understood by the man in the street, industry or business means an undertaking where capital and labor cooperate with each other for the purpose of producing wealth in the shape of goods, machine tools, and for making profits. The concept of industry in its ordinary sense applies even to agriculture, horticulture, pisciculture, and so on and so forth. It is also clear that every aspect of activity in which the relationship of employer and employee exists or arises does not thereby become an industry as commonly understood. We hardly think that in terms of an industry when we regard, for instance, to the rights and duties of a master and servant, or of a government and its secretariat, or the members of the medical profession working in a hospital. It will be regarded as absurd to think so. At any rate, the layman unacquainted with the advancing legal concepts, what meant by industry would rule out such a connotation as impossible. There is nothing, however, to prevent the statute from giving the word industry and the word industrial dispute a wider and more comprehensive import in order to meet the requirements of rapid industrial progress and to bring about, in the interest of industrial peace and economy, a fair and satisfactory adjustment of relation between employers and workmen in a variety of fields of activity. And it's obvious that the limited concept of what an industry meant in early times was now revealed to play the enormously wider concept is to make in various and varied forms of industry so that dispute arising in connection with them might be settled quickly, the dislocation, disorganization, so and so. A few lines later, the conflicts between capital and labor have now to be determined more from the standpoint of status than of contract. Without such an approach, the numerous problems that now arise for solution in the shape of industrial disputes cannot be tackled satisfactorily. And this is why every civilized government is thought of the machinery of conciliation officers, boards and tribunals for the effective settlement of disputes. So what was in the antechamber of the mind of the court was rapid industrial progress and all possible emanation that may happen by rapid industrial progress. And therefore, what should we do to address the questions of industrial peace? Now, the dynamics of industrial law, even if incongruous with popular understanding, is the first proposition we derive from Banerjee. Legislation has to keep in pace with the march of times and to provide for new situation. Social evolution is the process of constant growth, and the state cannot afford to stand still without taking adequate measures by means of legislation to solve large and momentous problems that arise in the industrial field from day to day almost. And now let me take your lordships further to paragraph 29, at page 28. Because look at how the pendulum has been swinging between, on the one hand, we knew industrial changes happening across the globe and ways and means of producing goods and making services available are also undergoing change. At the same time, para 29, we'd only add that a developing country is anxious to preserve the smooth flow of goods and services and interdict undue exploitation. And toward these ends, labor legislation enacted must receive liberal construction to fulfill its role. For when you talk of a liberal construction, and where will you draw a line? Much later in the course of the judgment, even Justice Krishna says, how do you draw a line? It finds fault with the Hospital Mazdoor Sabha wanting to draw a line and says, how do you draw a line? So the drawing a line can be sometimes chimerical, sometimes it's like chasing a chimera. So I'll read a few more paragraphs of this and then try to place my comments. Paragraph 31. At the end, after I read many paragraphs from Bangalore Water Supply, they all ultimately towards encapsulating what is found in paragraphs 140, 141, and 143. Para 31. Absence of capital does not negative industry. Nay, even charitable services do not necessarily cease to be industries definitionally, although popularly charity is not an industry. Interestingly, the the learned judge dealt with a point. After enumerating typical municipal activities, he concluded, some of these functions may appertain to and partake of the nature of an industry, while others may not. For instance, there is a necessary element of distinction between the supply of power and light to the inhabitants of a municipality and the running of a charitable hospitals and dispensaries for the aid of the poor. In ordinary parlance, the former might be regarded as industry, but not the latter. The very idea underlying the entrustment of the duties and functions to local bodies is not to take them out of the sphere of industry, but to secure the substitution of public authorities in the place of private employers and to eliminate the motive of profit making as far as possible. The levy of taxes for the maintenance of the service of sanitation and the conservancy of the supply of light and water is a method adopted and devised to make up for the absence of capital. The undertaking of the service will still remain within the ambit of what we understand by an industry, though it is carried on with the aid of taxation and no immaterial gain and no immediate material gain by way of profit is envisaged. This is a very powerful statement, but I think I'll pause here for a minute because both city of Nagpur, which follows Banerjee, and Banerjee follows all those earlier Australian judgments, which go on to say that municipal activities need not be necessarily kept out of the purview of an industrial concept. Now, if today they kindly again read that paragraph, at the middle of the paragraph, the very idea underlying the entrustment of such duties of function to local bodies is not to take them out of the sphere of industry, but to secure the substitution of public authorities in the place of private employers. Now, we have a long history of municipal corporations, both in England and in USA, where there are private charters given to municipal corporations. You are a body of inhabitants, you have a corporation where you have some charter, you undertake all those activities. But when you move away from a private charter, where a body of inhabitants may do whatever they need to fulfill their needs, to a body created under law, with a certain constitutionally or legally, created mandates, then would you not think that there is a paradigm shift in the very basis of removing from a privately managed affairs, which now being managed and discharged by public authorities? So there is somewhere, I find in the course of the discussion, both in the city of Nagpur and in Banerjee, the court falls for a consideration, whether it is private or public, it does not matter, as long as there is it satisfies human needs and wants by whatever arrangement it happens, they would definitely fall within the scope of an industry. I'll take your lordships to Subbarao judgment in Nagpur a little later. So kindly now turn to paragraph 34.
"34 to 44 is a reference to the domestic law at that time. 40 up to paragraph 44, the lordships are referring to the previous judgments of this court.
Yes.
Right.
And 45 onward, then there is a reference to the international viewpoint.
Correct. I thought I'm going to, for my purposes, I'm not going to focus so much on clubs and associations, etc. That's on a different footing altogether. My focus is on primarily on these functions which will be now assigned to what constitutionally are legally mandated field of activities. And number one, and number two, where the both the 82, I'm sorry.
Sense of democracy at the grassroots level in terms of the constitutionalism now.
For instance, we have the 11th and the 12th schedule. Panchayats and municipalities that are now called upon to discharge several public utility functions. So my focus mostly on that. But before I go that, I don't think the new code in any way, directly or indirectly, echoes, I may say that, echoes an anti working class stand at all. It says, it captures paragraph 140 very lucidly. At the same time, I want to take some kind of concern to say what would not necessarily fall into a definition of industry, the kind of sovereign function that, though it says activities relatable to sovereign function. The new code could have gone into Bangalore water supply or any treatise on what is sovereign function today, but it does not do that. It cannot possibly, a legislature could not have enumerated what for all time would be a sovereign function. And therefore it says sovereign functions, activities relatable to sovereign functions. Therefore, that will be an outer fringe, the penumbra of sovereign functions, where an outer fringe of activities may also be so relatable and therefore would not be included. Therefore, the new code I find has very carefully guardedly phrase this definition. So please keep that in mind. And we go to paragraph. I want to read a few more paragraphs to find out why is there a common running thread. The common running thread, as we find in the ultimate paragraphs of judgment, is systematic activity, no doubt, no difficulty at all. Employer-employee, can't be any difficulty. And then if there is no profit motive, there is some issue somewhere. So when you come back to paragraph 140, where it talks about distribution of goods and services. So distribution of goods and services is a gray area where we can have a room for disagreement and what kind of services and what kind of service. Suppose I have a ICMR, and then there are even rice research. So the areas of research where they are directly geared to a certain supply of services directly and indirectly, and to enhance, let us say, community health. We have hundreds and hundreds of programs today, both at the central and the state government level, towards child nutrition. And then, for instance, and maternity benefits, so on and so forth. I got a large number of the list of those programs. And they are meant to be in support of advancing many provisions in the directive principles of state policy. So we have those difficulties when you talk of production, distribution of goods and services. That's why I was trying to tell your lordship that the word undertaking has probably led to a large amount of discussion on whether some activity would be an undertaking or not. And there you again fall into the question of nocita sources, ejusdem generis. And let me please keep all that in mind. Paragraph 34 at page 30. In short, trade embraces functions of local authorities, even profession thus departing from popular note. Another facet of the controversy is next touched upon, that is, profit-making is not a sine qua non of industry, functionally or definitionally, but these powers they in federal, municipal, so and so, considered an industrial, with empirical approval with the Australian High Court, considered an industrial legislation. Then I read it a little later, because when you talk about municipal city of Nagpur and Banerjee, this may have some bearing.
Para 44, Nagpur discussed.
Yeah, paragraph 38.
44.
37 and also 38, because the court enters into a little dense domain of drawing lines, but then it does draw lines. Para 38. 1 minute. Yeah, para 37. The limiting role of Banerjee must also be noticed so that a total view is gained. For instance, analogous to trade or business, cuts down undertaking, a word of fantastic sweep. Spiritual undertakings, casual undertakings, domestic undertakings, war waging, policing, justicing, legislating, tax collecting, and the like are prima facie pushed out. Wars are not merchantable, not justice saleable, nor divine grace marketable. So the problem shifts to what is analogous to trade or business. As we proceed the next set of cases, we come upon the annotation of other expressions like calling and get to grips with a specific organization which call for identification in several appeals before us. Fortunately, as we see the new code, it doesn't borrow the old code, trade, business, undertaking, etc. It now essentially takes into account what is available in paragraph 140. Therefore, post the new code, the question of what will be an undertaking need not deter the code unless by forensic ingenuity at the bar, we try to bring it back and say, well, undertaking can always be loomed large behind the definition of industry, even in the new code. So I read paragraph 38 now. At this stage, a close-up of the content and contours of the controversial words, analogous, etc., which have consumed a considerable time of counsel may be taken. To be fair, the pathfinding decision which conditioned and canalized and fertilized subsequent juristic humanistic ideation, we must show fidelity to the terminological exactitude of the similar expression, use and search carefully for its import. The precise words are branches of work that can be said to be analogous to the carrying out of a trade or business. The same judgment is negative, the necessity for profit motive and included charity impliedly has virtually equated private sector and public sector operation and has even perilously hinted at professions being trade in its perspective, the comprehensive reach of analogous activities must be measured. I ask myself the question, is it possible for the court to have such a measure at all, except to a certain limited and agreeable extent, where there can be a broad agreement? The similarity stress relates to the branches of work, and more the analogy with trade or business is in the carrying out of the economic adventure. So the parity is in the modus operandi, in the working, not in the purpose or of the project, nor in the disposal of the proceeds, but in the organization of the venture, including relations between the two limbs, namely labor and management. I think that is why in the new code, this aspect of the definition, which is thought to be filled in here, is very wisely avoided. If you look at parity is in the modus operandi, not in the purpose of the project, nor in the disposal of the proceeds, but in the organization of the venture. So you can probably bring in many things by applying this very widely stated proposition. If the mutual relation, the method of employment, and the process of cooperation in the carrying out of the work bear close resemblance to the organization, method, remuneration, relationship of employer and employee, and the like, then it is an industry, otherwise not. An activity-oriented, not motive-based analysis. Is it, I sometimes wonder, with all humility to the learned judge, whether this not motive-based analysis is also a very sweeping proposition. Then we have paragraph 40.
Bench wanted you to.
That's it, that's on 44.
44, I come to. Paragraph 44 at page 34. But I think it's also useful to read in the previous paragraph at the top of that page 34, the previous paragraph 43. It begins like this: filling the gaps in the Banerjee decision and the authoritative connotation of the fluid phrase analogous to trade and business were attempted to these twin decisions. To be analogous is to resemble in function relevant to the subject as between like features of two apparently different things. So some kinship through resemblance to trade or business is the key to the problem, is a guide star. Partial similarity postulates selectivity of characteristics or comparability, wherein lies the analogy to trade or business is then the query. As a quote further to get on into the query, I think the query is only partly answered. Because the query could not be finally answered at all. The query could be answered on a given set of factors which present, unless we have some fundamental postulates on which there can be no disagreement whatsoever as to what would constitute an industrial activity. That's why I think both the 1982 and the new code picked up 140, paragraph 140. So those postulates are very clear. In the context of a trade or a business or any similar activity, you will have a systematic activity, an employer and employee, and the production or distribution of goods or services. But then if you pick up any one of an isolation, then there could be a problem. If you look up in isolation only a production, distribution of goods and services without reference to the other thing, that could be a problem. If you close your eyes to the nature of the activity, sometimes that could be a problem. Therefore, these are imponderables. You cannot put into a box which you can seal them forever. Now let me read para 44, page 34. That Subbarao, with uninhibited logic, chases this thought and reaches certain tests in Nagpur municipality. Speaking for a unanimous bench, we respectfully agree with much of his reasoning and proceed to deal with the decision. If the ruling were right, as we think it is, the riddle of industry is resolved in some measure. Although foreign decisions, words and phrases, lexical plenty and definitions from other legislations were read before us to stress the necessity of direct cooperation between employer and employees in the essential product of the undertaking, or the need for the commercial motive of service, the community, etc., as implied inarticulately to the concept of industry, we bypass them, but marginally persuasive. The rulings of this court, the language of the scheme of the act, and the well-known canons of construction exert real pressure on our judgment. And in this later process, next to Banerjee comes Corporation of Nagpur, which spreads the canvas wide and eliminates the expression analogous to trade or business, although it comes a few days after Hospital Madhu Sabha decided with the same bench. I feel that.
57, 48 and 51.
After quoting at page 45, sorry, or page 35, quoting from an ILO on freedom of association at the bottom, at page, paragraph 47 at page 35. This divergation was calculated only to emphasize certain fundamentals in the international industrial thinking which accord with a wider conceptual acceptation for industry. The wings, the word industry have been spread wide in section 2J and has been brought out in the decision in Corporation Nagpur. That case was concerned with a dispute between a municipal body and its employees. The major issue considered there was a meaning of the much disputed expression analogous to the carrying on of a trade or business. We find that the text itself did not have that word. Therefore, when you want to read what the meaning of an undertaking, you have to find out some kind of a step book to find out what expressions, words, and principles can be used for the purpose of determining what is undertaking. Therefore, the major issue considered was the meaning of the much disputed expression analogous. Municipal undertakings are ordinarily industries, as Baroda Borough Municipality held. Just make a note here, Baroda Borough Municipality follows Banerjee. And even so, the scope of industry was investigated by the bench in the city of Nagpur, which affirmed Banerjee and Baroda. The court took the view that the words used in the definition of prima facie or the widest import and declined to curtail the width of a meaning by invocation of no-citer sources. Even so, the court was disinclined to spread the net too wide by expanding the classic expressions calling service, employment, and handicraft. To be over-inclusive may be impractical, and so while accepting the enlargement of the meaning by the device of inclusive definition, the court cautioned. But such a wide meaning appears to overreach the objects for which the act was passed. It is therefore necessary to limit its scope on permissible grounds, having regard to the aim, scope, and object of the whole act. If therefore the court was looking at calling service, employment, and handicraft not to be widely seen, I suppose even the word undertaking, which must take color from trade, business, etc., if you spread the net very wide. And for that purpose, you call what is analogous to trade and business. And therefore, that's a problem where this court tries to face and tries to answer in its own independent way. Then paragraph 50, 51, 51. Page 50, sorry, paragraph 50 at the bottom of page 36. The court proceeded to carve out the negative factors which, notwithstanding the literal width of the language, the definition must, for other compelling reasons, be kept out of the scope of industry. For instance, sovereign functions of the state cannot be included, although what such functions are has been aptly termed the primary and inalienable functions of a constitutional government.
We need not to go into these. So at that time, whatever the globally the jurisprudence was developing, that has been referred to. So you take note of that.
Yes.
Coming to the conclusions drawn, and then would like to have your own notes here. Questions to.
No, I thought a little more reading. I'll conclude because it goes on how to iron out the creases and what is felt the absence of certain factors in the definition. And then the court says, what is the statute we are looking at? It is a worker welfare oriented statute. And therefore, the purpose of the act must be so fulfilled in order that I do not truncate the mission of the act. So while doing so, whether the court probably drew a line somewhere which continued activities would not be in the nature of an undertaking analogous to trade or business, and also while looking at functions which are now essentially what I may call constitutionally mandated public purpose activities, which are now drawn through different parts of a constitution. And most importantly, we say in the Schedule 7, your allocation of legislative functions and administrative, executive functions, you find a whole lot of them, which perhaps would not fit in with the old narrow concept of sovereign functions, inalienable, etc. For the concept of sovereign functions, even though it has been retained in the new code, it will receive its color from an entirely new conceptual way of understanding those, what I would call again repeatedly, constitutionally mandated fields of activities where the determination as to in what way I will exercise these activities, in what way I will pursue these activities, and in what manner, for the purpose of executing them, I will have a certain framework. It could be an establishment, it could be directly done, it could be indirectly done. Therefore, when we enter into that, to say that in paragraph 50, where I said the primary and inalienable functions of a constitutional government, we go back in point of time to what was originally in international law, sovereignty concept, and again between state and state, or we again fall back in the judgment I will read from Nagendra Rao, in the field of civil law, torts. We have moved far away from the act of state principle. Therefore, the state is liable for a wrong committed by a servant or an employer, but they are in the field of civil wrongs. But when you come to an entirely different domain of activities where in the exercise of its, I said, constitutionally dictated functions, whether you could probably truncate and confine, a crib cabin confine, as I may call it, the sovereign functions aspect and go back on very historically outdated understanding. That's why I thought I'll read paragraph 50. Yeah. Kindly turn to paragraph 51. I'll quickly read through some of them. I was 51. Although we are not concerned in this case with those categories of employees who particularly come under the department's charged with the responsibility.
To the conclusion of this, then for the rest of it is after this, education and all these things individually start. We don't.
All these paragraphs are ultimately crystallized
I'm
in
sorry.
paragraph 140, 141 onwards.
Correct. It crystallizes. I thought this. I thought some
Not
plans.
position on the conclusions of the judge bench.
I'll immediately come to that, but why I thought some paragraphs need to be read is what was the thought process which went into the mind of the court in saying what do you pick up from each one of the judgments? Do they have a connecting thread? Is there a connecting thread available in all these judgments? So that ultimately I find out what are those connecting threads which I can call out as principles for the determination or the definition of industry. So these are very important milestones with the court crossed.
Just highlight them, that's all.
140, paragraph 140 is actually connected.
I'll come to paragraph 140. Page 73. Page 73. Industry as defined in section 2J and explained in the wide report. So these are three principles with the court calls out from this decision as on their analysis. But then B, C, D, I think let us look at it. Absence of a profit motive or gainful objective is irrelevant, be the venture in the public, joint, private, and other sector.
It may not be also. But they say there is.
After this,